about the Dari decision, and the second reason why I say that Dari is distinguishable, is as follows. Unlike in this matter, where the issues, where the facts upon which the application for recusal are based have been judicially considered and a decision given, and that decision is contained between paragraph 74 and paragraph 96 in the decision you delivered in this matter yesterday. In Dari, the issues that the Supreme Court then suo moto relied on to recuse themselves had not received any judicial consideration. Yes, those facts went on to become a complaint before the Judicial Service Commission. In the same way, the facts that form the basis of your determination between paragraph 74 and 94 of your decision have gone on to the Judicial Service Commission as a complaint. But those facts now forming your decision, the proper thing to do is not to complain to the JSC but to appeal. That is the proper thing to do. So to then file a complaint before the JSC and then reach for Dari out of context is wrong. And for those reasons, that Dari decision is distinguishable. And I urge you to distinguish it. The second decision that I wish to urge you to distinguish is the decision that was cited by my good and learned friend Mr. Tom Macharia, the Navin Premji Kerry versus Virunga Limited decision. And the reason I want to urge you to distinguish that decision is as follows. A true reading of paragraph 5 and paragraph 6 of that decision show that the arbitration commenced on the 31st of March 2021. The traditional reading which the judge then took offense to took place on the 18th of February 2022. So it is clear, and that is clear from a reasonable process of deduction, that the traditional wedding then took place during the currency of the arbitration. That is not the case here. The screen graph that has been produced of Mr. Justice Mrima and the Speaker of the Senate, if we are to believe that it is true, is dated the 9th of October 2021, more than 3 years ago. So this decision is distinguishable on the facts. Judges do not live in glorious isolation. Your appointment as a judge does not mean that you cannot invite your friends to a wedding. On the 9th of October 2021, Mr. Justice Mrima did not know that he would have to go through the torment of sitting on this bench. In respect of the Manchester Outfitters decision, I also submit that that decision is distinguishable for the following reason. Mr. Justice Laka had been an advocate for one of the parties. Again, in an advocate-client relationship, the client pays the advocate fees. And that relationship is not at play here. And for those reasons, I urge you to distinguish that decision. My Lord, there are two pieces or two annexures that we wish to make a specific submission on. And that annexure is the screen grab from Amason Kingi's account and the prophecy by learned senior counsel Ahmed Nasir as to what would take or what is going to happen in this matter. My Lord, those are electronic evidence. And those are electronic evidence I submit within the meaning of Section 106B of the Evidence Act. In the absence of a certificate required by Section 106B of the Evidence Act, that evidence is not admissible. My Lords, it has been submitted by those who have submitted before me in opposition of the application that the petitioners are guilty of forum shopping. I wish to persuade you whilst on my feet this evening that this application is a further attempt at forum shopping. My lords, my lady, you will note, because you are seized with petition number 522 of 2024, that on the eve of the impeachment hearing, the petitioners insisted at an hour not too different from this that you hear their application for conservatory orders. The application was heard, and you, with exceptional dispatch, delivered the ruling the next morning at 8:30 in the morning. My lords, my ladies, after the ruling, the learned counsel who were in court for the petitioners engaged you in a lengthy submission, which appears to be their stock in trade, on a request for leave to amend that petition. And the requirement or the request that they wanted, or the reason why they wanted leave, was they envisaged that perhaps after the impeachment proceedings in the Senate, there may have been need to have recourse to court and seek certain orders. But what did the petitioner do? The petitioner, we are told that he was unwell.
Family.